Welcome to Sovereign Citizen Legal Encounters. All right, the Ponzi scheme Sovereign Citizen is back in court again because he had another follow-up hearing. So we're going to check that out. But also, I have his first two hearings in there, and I've already done commentary on them. So you'll see my commentary from the first two, and then the last one is going to be commentary from this video right here. Huh? Let's go.
Yes. Next, I have Jose Elizondo.
Good morning, Your Honor. My Christian name is Jose, and my family name is Elizondo. I am the bailiff today, and respectfully, I have some issues to raise.
Wait, Mr. Elizondo, wait. Jose Elizondo, I show that you have one case pending, and that is expired registration. Do you understand that's the charge that is pending against you?
Yes, I understand, but respectfully.
Okay, sir. Okay, hang on. There's several steps we need to take over. Were you able to hear my explanation about defendants' rights and options that I went over at the start of court?
Yes.
Do you have any questions about those rights or options?
Yes.
Go ahead. What's your question?
Okay, respectfully, I haven't received my documentation that I requested in a timely manner to proceed today.
No. What is your question? No, Mr. Elizondo, no. What is your question about the rights and options that I went over at the start of court?
I have no questions regarding that. Okay,
then to this charge of expired registration, actually, I'm going to stop and say, you mailed in payment.
I did.
You mailed in $3 and you have a balance due of $129. So with that payment of $3, we've already entered a plea of no contest for you because Texas law allows that to be entered for you. So we're set here to determine, are you able to make the balance of your payment by Monday, or do you need some time to pay that out?
Your Honor, respectfully, as a bailor and grantor, I've granted this court equitable title for settlement of any.
No, sir. This is a criminal court. No, sir. Mr. Elizondo, this is not a civil court. There are no parties like that in this proceeding. You're a defendant. You're not a grantor. I'm the judge, and so that does not apply to this court. You may have read that might be something in a civil court. That does not apply here. So my question to you, sir, is since you've already mailed in payment and indicated a plea of no contest by mailing in a payment under Texas law, can you get the balance paid by Monday, or do you need some time to pay that out, or do you have a financial situation that you need a financial packet?
Your Honor, for the record, respectfully, I am a Texas common law free man. I do not participate in corporate Ponzi schemes that require me to have registration.
This is not that, sir. This is not, Mr. Elizondo, stop. Mr. Elizondo, stop. This is not the time to make a statement. You see, we have like 12 other people who are set here. You're set on a criminal charge. This is not time for you just to go and make a statement about a civil matter that it is not set in this court.
So are you saying that I don't have civilian due process of law?
No, but this is not a civil matter. You're raising terms in regards to this as if this were like a civil lawsuit. This is a criminal charge where you've already. It's not
criminal, Your Honor.
Yes, it is, sir. This is a Class C criminal charge in Texas, displaying an expired registration. That is a Class C criminal charge, and you mailed in partial payment. So I'm trying to determine, are you able to make the rest of your payment by Monday, or do you need some time to pay it out?
I have the right to equitable title for this settlement or any charges on the doctrine of trust merge.
This is not a matter. This is not a matter of a title to a vehicle or anything like that, sir. You seem to be confusing some civil law.
Well, I have some confusion because on Supreme Court case law Murdoch versus Pennsylvania, they clearly state that you don't need registration or insurance for private personal travel, and I don't consent to any corporate Ponzi scheme.
To make a correction, in Murdoch versus Pennsylvania, the Supreme Court ruled that a Pennsylvania city ordinance requiring a license tax for distributing religious literature door to door violated the First Amendment. The decision was made in 1943, and the court held that the tax infringed upon the free exercise of religion, free speech, and free press.
Okay, well, this is nothing to do with a corporation. This is a Texas charge, and you've already mailed in a payment for this. So you've indicated a plea of no contest. Are you saying that you're not pleading that? Then why did you give them $3?
As a bailor and grantor, I gave
Mr. Elizondo, stop. Mr. Elizondo, stop. Mr. Elizondo,
of trust merge.
Mr. Elizondo, stop. Why did you mail in $3?
Because as a bailor and grantor, I have granted to this court equitable title for settlement of
No,
any
sir, we do not settle. And
charges
sir,
under trust
Mr.
merge.
Elizondo, there's no party in a criminal charge that's called a bailor. And you cannot claim a position that is not one in this court.
Your Honor,
There's
are
no
you giving
status
me-
of bailor.
Are you giving me finance?
No, sir, listen, I
Hello?
need you to listen to me. I need you to listen to me. There's no status of bailor or grantor in this criminal court. You may have read some cases in regards to some other matter. You are a
Can you give
defendant.
me-
No, Mr. Elizondo, you need to be quiet and listen. You're a defendant. You mailed in $3, which is partial payment of a total of $132. All right. Now, by law, when you mail in a payment, a plea of no contest is entered. All right. So my question to you was, when you mailed in the $3, was that your intent to make a partial payment, requesting a payment plan, or were you attempting to post a bond?
My intent was, like I said, I am the bailor and grantee. I have granted this court equitable title for settlement of any charges under doctrine of trust merge. That's my answer to your question.
Okay, that is not an answer that applies in criminal court. So based upon your payment of $3, the court has already entered a plea of no contest, and I'm going to order that you get the balance paid
Your Honor,
within 30
respectfully.
days.
Okay, Your Honor, respectfully, with those documents that you have, I didn't receive any documentation requested in a timely manner to proceed today. Outlining my full warranto under Chapter 66 of Texas Civil Practice Code, which
Okay,
is
stop,
provable
Mr. Elizondo,
and
Mr. Elizondo, stop. The Civil Practice Code does not apply to this courtroom. This is the Code of Criminal Procedure applies to the criminal courtroom. So the Civil Code does not apply.
But I still have a civilian due process, Your Honor.
Well,
And I have
yes,
not
but
entered a plea.
you did by mailing it in. By mailing that in, that's entering a plea of no contest. You mailed in a payment of $3.
Your Honor.
You can
Like
get
I
the
said,
balance paid.
the reason why I did that as a bailor and grantor, like I stated multiple times, I've granted this court equitable title for settlement.
Okay,
under
Mr.
any
Elizondo.
document of trust merge.
Mr. Elizondo,
A bailor is a person who temporarily gives up possession, but not ownership, of a good or property to another party, known as the bailee, under a bailment agreement. For example, you go to a rental car company in order to get a rental car that you need. Well, they're the bailor, you're the bailee, you sign the contract, you get the car for a short amount of time until you take it back.
were you wanting to plead not guilty and request a trial?
No. Respectfully, Your Honor. Constitutionally, too. For the record, I am a Texas common law free man. I do not participate in any Ponzi schemes that require me to have registration and insurance. I do not consent quasi-jurisdiction. Respectfully, Your Honor, I plead for a civilian due process of law.
Okay, well, you're
Under Section 1, Article 10.
Okay, Mr. Elizondo, you're receiving the exact same due process that every other person who's appeared in this court has. And you have mailed in a payment of $3, and that payment is received as a plea of no contest.
Who is my accuser, Your Honor? Respectfully.
The state of Texas. That citation that you received, that is the accusation. And
Okay, well, I would like to go to trial for this.
so you're indicating that you wish to change your plea from no contest to not guilty?
What is he looking up for?
Yes.
All right. And you wish to waive your right to jury trial, or do you wish to request a jury trial?
No.
So no jury trial. You wish to waive your right to a jury trial?
1 second, please. Never mind. Give me a jury trial, please.
Oh, okay, he's been reading from the script, and I think he got a mentor in the back.
So you wish to request a jury trial?
Yes.
And you will be representing yourself, or will you be retaining counsel?
Myself.
Okay. Do you understand that if you request a jury trial, if you're found guilty, in addition to the regular state court cost, there is an additional jury trial court cost that's assessed if you're convicted. Your case is going to be reset for a pretrial hearing. That is going to be for our May contest docket, which is at 6 p.m. on May 7th. Now, you will receive a written pretrial order. Make sure you read it and follow it. If you wish to have any motions heard you need to have them filed pursuant to the order, so they will be heard that night. If you have any requests for jury charges, you need to have those prepared and filed that night. You will have an opportunity to speak with the prosecutor, and you will have your hearing on any motions that night. At that time, we will schedule your jury trial for a later date, so have your calendar ready. Be prepared to know your availability for the next 2 to 3 months after the May 7th docket. Watch your email. You'll receive the pretrial order. You should get it by Monday at the latest. If you haven't received it by then, call my court staff. They will resend it to you. Make sure you send everything in writing in response to that. If you have any requests for discovery, if you have any other motions you want the court to consider, they must be filed pursuant to the order. Do you have any questions about that, sir?
No, Your Honor. Thank you so much.
All right, we'll see you back here May 7th at 6 p.m.
Yes, ma'am. Thank you.
Here you go.
All right, we got the first hearing down. I'm sure you enjoyed that. Now we're going to go into the second hearing. But I will tell you, and I'm sure you noticed, when he gets out of hand, the judge starts yelling, tell him to stop. She cuts that off. That's probably not her first sovereign citizen she dealt with. Huh? Let's go to the second hearing and check everything out. Let's go.
Mr. Elizondo, you have case G 4791701, charges expired registration. You were in court in April 1st, I believe it was, and indicated that you wish to plead not guilty and represent yourself, but you were not waiving a jury trial. So we set this for pretrial hearing. Court issued a pretrial order that was sent to both parties. I do not show that either side filed any motions or requests for subpoenas or request for jury instruction. Mr. Bishop, did the state file any?
No, Your Honor.
Okay. Mr. Elizondo, did you file any?
Yes, I actually certified mailed it to y'all. I have the receipt right here.
When was it mailed?
It said you should have received it on the 1st of this month. It was mailed on 04/29/2025.
We don't have it.
Well, you should have received it on the 1st. I certified mailed it.
Do you have the green copy back?
I have it right here.
No, the signed that it was delivered.
I mean, I have a tracking number here, but I haven't tracked it. It just says y'all should have received it on the 1st.
Well, we have not received it. We have not received anything. And everything was supposed to be filed with the court no later than 7 days prior to the pretrial hearing. So if you were sending it in on the 29th, you were not getting it here within the 7 days. What's the tracking number?
It says it shows delivered on my side, but let me see. Let me pull it up. The tracking number is 9589.
Whoa, go slowly. Go slowly. I'm going to take this down and we're going to check 95 what?
9589071052703070.
Let me read that back to you. Check and make sure I have this correct. 95890710527030018077.
And then at the end, it has a 12.
12.
Yeah. That was correct, though.
All right.
Read about it.
Court is going to go into recess and look up the tracking number. Everyone stay logged in, but we're going to be in recess. All right, Mr. Elizondo, Mr. Bishop. So, Mr. Elizondo, I just had my court staff run that number through USPS tracking, and it does not show that it's been delivered.
I also had my staff running through the system, and I don't show it being delivered either. Here's the screenshot to show you where it is in progress right now. And to further add, they never get motions to the court. Now he can't mail his package in properly. I'm sure he didn't send a priority mail, and who knows, he may not even send it to the court.
You did not have any written motions or requests for anything. Is that correct?
That's correct.
Okay, so then, since you don't have to post a bond because you have a promise to appear, we can go ahead and set this for jury trial. So jury trials will be during the day. We'll start at 9 a.m. Parties are to be here at 8:30. The veneer panel will be here at 9, and we'll have the trial. So the first date that we have is August 28th, which is a Thursday at 9 a.m. All right, so Mr. Elizondo, we're going to set this for trial Thursday, August 28th. At 9, you need to be here at 8:30. This will be in person in the courtroom.
That's fine.
If you are planning to call any witnesses, you need to have them here, present, to be sworn in and able to testify. Understand?
Got it.
Okay. Do you have any questions about this?
No. Well, are you going to send me this information via email?
We're going to send you a reset notice. Yes. Yes.
Make sure that email is correct, because today I received the email saying this court hearing was going to be at 6 a.m.
Make sure. Will he think he the chief judge?
And I was present.
Sir,
and it was
I
6
apologize if there
p.m.
was a typo. I do know that you also received numerous communications from the court that said 6 p.m. And when I set you for this hearing, I told you it was at 6 p.m. So you were advised that by the judge, and we have copies of emails and documents that were sent.
And make sure
Sir,
that
Mr. Elizondo, do not speak to the court that way. You may make a request, but do not speak to a judge and tell them to make sure to do something. Do you understand me, sir?
Yes.
All right. You are set for jury trial on August 28th at 8:30 in the morning. The veneer panel will be here at 9. You'll have an opportunity to ask questions of the veneer panel, make any strikes that you wish to have. We will have the trial on August 28th. Make sure you have any witnesses here, any evidence that you're wishing to present, have it here and marked and ready to be admitted. All right. We will send reset notice, setting notice to the same email address that we've sent the other notices to. Mr. Bishop, is there anything that the state needs to put on the record at this time?
Nothing from the state, Your Honor.
Okay. Mr. Elizondo, if you don't have any further questions, then you are going to be released. We'll see you back here in person on August 28th at 8:30 a.m. All right, you're released at this time.
Now you're caught up on the hearings for the ones that haven't seen it before. So now we're going to go into the most recent hearing where he filed a couple of motions to come back in court before he had his trial. Now the judge, as you see, is already dealing with how his attitude is. So let's see how this is going to play out and see what happens in this hearing. Let's go.
So the first case set for motion is Jose Elizondo. Mr. Elizondo, if you can please unmute and show your video.
I'm here.
Okay, thank you. So, Mr. Elizondo, you had a pretrial hearing earlier this year in May, and then at that hearing, you had indicated that you had mailed in a motion for a bond, and that was the only motion that you had, and we did not have that here. After the court, and we set your case for a jury trial on August 28th. Then after the date of your pretrial hearing, we received a motion in the mail stating defendant's Rule 91 motion to dismiss for failure to state a claim upon which relief can be granted. Mr. Bishop, have you received a copy of that motion?
Your Honor, and made a response.
Thank you.
I believe he's filed 2 motions. I've got a motion to dismiss and then a motion, no consent given motion.
Yes, that's correct. All right. So, Mr. Elizondo, if you wish to summarize your argument, you may do so at this time.
Yeah, I just want to know, do y'all enforce the Texas Transportation Code?
No, sir, we're not answering questions. You need to summarize your motion at this time.
All right, well, I just want to add to my motion that according to the Texas Transportation Code, Title 1, Section 502.003, clearly states it prohibits political subdivisions from requiring registration, and my violation was due to registration. So that's all I wanted to add, and I plead not guilty and for dismissal too.
Mr. Bishop, your response?
Yes, I addressed this in my response, Your Honor. The city of Dalworthington Gardens is the political subdivision of the state of Texas. And this registration requirement is not a violation of a city ordinance. There is no city ordinance that requires individuals to register their vehicles. That's state law. And so the defendant is incorrect in applying that statute because it's a state law violation, not a city ordinance violation.
The court has read the defendant's motion to dismiss, and I have read the state's response to that. And the court is denying the defendant's motion to dismiss.
We knew that was coming.
Don't see where you prepared an order for me to sign. Let me see.
I did not prepare one, Your Honor, but I will be glad to prepare one.
Okay, if you can prepare one, Mr. Bishop, I will get that signed. I'm writing a notation here. Motion denied. Right. And then we have the second motion, defendants, no consent given. Mr. Elizondo, you may summarize your argument at this time.
Whatever I submitted is what I plead to continue with.
No statement?
Mr. Bishop, we should summarize the state's response.
Yes, the state's response is in the state of Texas, driving is a privilege, not a right. And by exercising his privilege to drive on a Texas highway or street, he is subject to all rules of the road, statutes, and rules. And so the state does not need his consent for him to be subjected to jurisdiction when he has violated a state law. He's not being denied his rights. Driving is a privilege, and by driving, he subjects himself to the rules of the road and other state laws regarding driving.
All right, based upon the court has reviewed the written motion and response, motion by the defense, response by the state, has considered the arguments made here in court, and the court is denying the defense statement of no consent given to jurisdiction.
I knew that one was coming too.
Mr. Elizondo, your case is set for jury trial on Thursday, August 28th at 8:30 in the morning. That is when you need to be here. You have cited in some of your motions civil rules of procedure. As I have warned you before, I'm warning you again, the Texas rules of criminal procedure apply in this case. This is a criminal charge, and you need to follow the Texas rules of criminal procedure. You will be expected to follow proper courtroom decorum, and as you are representing yourself, you will be held to the same standard as if you were an attorney. You will need to be here at 8:30 in the morning. You will receive information regarding the venirmen, the potential jurors, and voir dire will start at 9 a.m. You will be given 15 minutes to ask relevant questions of the venire panel. The state will be given 15 minutes to ask questions of the venire panel. Each side is given the opportunity to make up to 3 strikes, and then we will proceed to the jury trial that day. Have any witnesses that you wish to call and any evidence that you wish to present here and ready when you get here at 8:30 in the morning. Do you understand, sir?
Yeah.
Okay. All right. Mr. Elizondo, is there anything else that you wish to put on the record at this time?
No.
Mr. Bishop, anything from the state?
Nothing further from the state, Your Honor.
Okay, Mr. Elizondo, you are released at this time. We'll see you here in person at 8:30 in the morning on August 28th.
Sounds good.
You are released at this time.
Well, there you have it. Now you're all up to date, and I'll see if we'll be able to look at that hearing from the 28th, because if he's in person, they might not air it. But anyway, you see he's still with the sovereign citizen tactics and antics and all of that good stuff. So I hope you enjoyed the video. Give it a thumbs up if you like it, and I'll see you around on the next video.